Ashley Sowers versus Adam Sowers.
For the record, this matter is before the court this morning on the plaintiff's motion to compel sale of real estate. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski representing the plaintiff moving party, Ashley Sowers, and Ms. Sowers appears to be present. In addition, Attorney James Petrangelo is present representing the defendant, Adam Sowers, and Mr. Sowers is also present. Good morning, everyone.
Good morning.
Good morning.
The parties have conferred this morning with Mr. Pratt from the front of the court, who has provided the court with the following recommendation. That the property listed at 6253, as well as the property at 6 Carlton, shall be sold in order to pay the agreed upon settlement amounts. Ashley Sowers shall provide an apostille. I'm not sure what that is for 6th Road. Not familiar with that term.
Did you want me to address that, Judge?
Further, it says in the event the home is refinanced part of sale, Mr. Sowers can maintain the properties. Yes, that's the recommendation. Ms. Gorski, can you explain what's APPOSTILE?
Yes, it's effectively an international notary because my client is in Canada. A simple notary isn't enough. And she had to do that before when she was in Mexico. She got an apostille. It's like a higher security seal.
Okay.
And of course, Your Honor, she is required to do whatever is necessary to cooperate to effectuate the terms of the judgment, and she will. She has in the past, and she will again.
Okay, so Ms. Sowers is still residing in Mexico, correct?
She's in Canada, Judge.
Oh, in Canada. Okay.
Yep.
So she needs to sign some documents for the West Newburgh Road properties. Is it still jointly held?
No, she quit claimed her interest over a year ago, and we learned today that what she signed a year ago apparently isn't sufficient. I've not seen any documentation. Judge, just to put it on the head of a pin and make it really simple for you, that you signed a judgment in December of last year that required Mr. Sowers to take certain action. And as I've set forth in my motion, she hasn't received a dime of her money. She was awarded $10,000 in January. She still doesn't have it. She was awarded $18,162.50 in March. She still doesn't have it. And next month, she's supposed to be paid $80,758.09. We don't have any confidence that she'll see that money either. Mr. Sowers is in arrears on his child support. But at any rate, you entered that judgment in December, and since then, there has been no communication on this issue between the parties or, quite frankly, counsel. I reached out to Mr. Petrangelo when his $10,000 check bounced that he made in January untimely. And since that time, I filed my motion March 22nd. I've not received a response to my motion. I've not received any proof of any attempts to refinance. I've not received any requests for her cooperation. So to the best of my knowledge and to the best of my client's knowledge, since this judgment entered, Mr. Sowers has done nothing. To the extent that he would present himself today and say that he has, I have no verification of that and no confidence that it's true. And I question his credibility. So that's where we're at today.
Right. Thank you, Ms. Gorski. And the court did thoroughly review all the pleadings. I'm aware of all those facts. And so you're asking the court to adopt this recommendation, Ms. Gorski?
I am.
Right. Mr. Petrangelo.
Yes, Your Honor. My client is actively trying to refinance these properties. What I did receive is a April pre-approval letter on one property, that being 6357 is represented. I can acknowledge that's not clear to me from this, but it does indicate on that property he's able to pull $55,546 out. He advises, and that's with Mutual of Omaha. He's been dealing with Rocket Mortgage, trying to get this done on the other property. He indicates that if that goes through, he'll have more than enough to cover all of these things that are represented. The, there is apparently some problem with the notary on one of the deeds, because it was clear from all the documents and the judgments that she was out of the country, and yet the notary says it's a notary acting in Virginia. So I think that's raised some questions, and I'm not saying they won't provide us whatever we need to get that taken care of. That's not the real issue. I am suggesting that if we're going to proceed with a sale, it would be fair and appropriate to have realtors come look at the property to get us some recommended pricing, because we're not just going to pick numbers out of the air, and then select a realtor and move forward. I would think we could do these things simultaneously, at least that far. Give him some time to try to complete his refinancings, have the research and information done to know what we would have it be listed for and with who when we come back. And the judgment says you may order the sale of one or both properties. You have the discretion to act in that regard. I'm just saying the common sense, fastest way is to proceed on both tracks, get the information so we could list, give him the time to close. And so that would be the real distinction I have with the recommendation, is that we should secure information from some realtors so that it could be listed, and let him proceed with the refinancing and give us a date to come back. I know my client would like longer, but I think reasonably 60 days to close on financing. And then if he closed on one and he had most of the money but not all, for example, the court would look at those things. If he hasn't done anything, I'm sure you're going to say, okay, you've had your extra time. Now we know the realtors. Now we know the amounts. Here's what I'm going to order. But I don't think right now you could pick a figure and be fair to both parties. So I think that's just a reasonable way to accomplish what we're all seeking to accomplish.
Mayor,
Mr. Petrangelo, this recommendation appears to provide for that. It does not specify a time frame in which it must be listed. It simply says that it must be sold. So obviously, Mr. Sowers needs to move quickly, and yes, contact realtors, get fair market analysis, and decide to choose what realtors you list with. But the court would agree we should schedule a review date, because in fact, if we don't move it on this, the court's going to appoint a receiver, and that's going to be an additional expense to Mr. Sowers. Mr. Sowers has an obligation to pay Ms. Sowers $18,000 some dollars by March 22nd. That's past due, correct? He owes another $80,000 on June 22nd, a month from now. So yes, and this recommendation says that if he can refinance in the meantime, fine. But again, this recommendation does not specify a time frame for that listing, and perhaps it should. So maybe what the court will do, in lieu of setting a time frame today, is to set this matter for review in 45 or 60 days. Mr. Gorski, because then the judgment does not provide any interest on these obligations, does it?
it provides 10% per annum for the real property settlement, and I don't think it does for the personal property. The 18,162.50 was for personal property. The 10,000 that's overdue and the 80,000 next month are on the real property, and they're at 10% plus the cost of enforcement and attorney fee, which would be attorney fees and the motion fee, of course. My concern is that in 45 days, Mr. Sowers won't have done anything. So I would like him to secure a realtor now and get it listed. I think any realtor would set it at the highest possible price the market would bear. The realtor is going to want to make the most commission.
Right. Mr. Sowers has known about this obligation for at least 6 months, and he should have had that refinancing well underway by now, Mr. Petrangelo.
I would indicate to the court he's advised us he's been working on this since December on the various properties. The problem with the deed he has indicated cropped up to delay one. I just think yes, of course, anytime someone's behind, they should have acted faster.
Well, it's not, there's no expense to Mr. Sowards to list this property. Any reason why the court cannot order that, should not order that he lists these properties within 30 days? I'll give him plenty of time to interview realtors and have the realtors get fair market analysis.
The problem with that, Your Honor, I think there's maybe a financial liability if you list it and the realtor comes back with a buyer after the closing, trying to get that accomplished. I would ask if the court would consider direct him to have this listed in 60 days. And that gives him his time to get the financing, time to secure these things, and that's a reasonable time. If he can't get it done in 60 days, then it's going to be on the market.
Well, but he's had 6 months to refinance, Mr. Petrangelo, and another 60 days to refinance. He's had plenty of time to do that. But this recommendation does not provide any time frame for listing the property. So what the court's going to do is adopt a recommendation to set this for review in perhaps 45 days. And if in fact it's not been listed, the court will most likely appoint a receiver. I'll see if Mr. Godfrey is going to act as receiver if it's not been listed.
And that would be at Mr. Sowards' expense?
Absolutely.
Jim, we need the apostle, even if it gets sold. We have to,
They understand there's a requirement that they provide any documentation needed for us to make this transfer, and just get me the directive, and I will pass that to Ms. Zagorski, and we will, if they hold us up from there, we can tell the judge.
We will not.
We're talking about 6253 only, correct?
Both.
Whatever you have a problem with.
Both parcels are to be listed. It doesn't specify a specified time frame, Mr. Soward, so you've got some time, but I'm going to set this for review in about 45 days. And there's no reason why it should not be listed. And of course, if you get refinanced in the meantime, then you can cancel the listing.
I did begin refinancing immediately in December, but I have a letter from Rocket Mortgage indicating that I had to pay the delinquent.
I object,
property.
Your Honor. I object. It's hearsay. His letter from Rocket Mortgage has not been introduced. I've never seen it. I object.
I sent a copy of that to Jim, and I submitted that already.
Right. If Rocket Mortgage wants, if they're not moving timely, you need to look at some other mortgage companies. Mr. Sowards and the realities maybe need to liquidate one or both of these properties.
Well,
so the court's going to order you list both properties for sale. There's no time frame. I'm going to set this for review in about 45 days. There's no reason why it should not be listed within that time frame. Mr. Gorski and Mr. Petrangelo, we have either July 2nd or July 3rd. I know it's close to the holiday.
Either one's fine.
The second would be the best day.
We either have 9 a.m. or 1:30.
How about 1:30 on the second?
Okay.
Jim, the children are supposed to be here at that time. I haven't seen the kids in 3 years. Why is she doing this at this time?
Well, it's not her. It's the court saying this. When will the children be here all summer?
No, for the month of July. I haven't seen the kids in 3 years, and the timing of this is obviously very not.
How about June 28th then? We'll review it June 28th before the kids get here.
Judge, I'm not in town on June 28th.
27th?
Yes.
We'd want to interfere with Mr. Soward's time with his children.
Okay.
Is Gorski available on the 27th, which is a Thursday?
What time do we have? Can we do it in the morning?
Yes, the morning is good. You said June 27th in the morning? That's good.
Okay. Okay, how about 8:30? I'm not sure what I have at that time, but we'll make it work.
Okay.
That's fine.
Okay, so Ms. LaPrette, if you could kindly just add that to the recommendation that the court will review status of the listing on June 27th, 2024. Anything further than this morning, Mr. Gorski, Mr. Petrangelo?
No, Your Honor.
No,
What if I can provide the financing is going to be the fastest, easiest way to get it settled.
Okay, hopefully you'll have that. You have some documentation that you've been approved for that when we come back on the 27th.
Okay, that's all I needed was the apostille. We would have already had this settled if I had the apostille, Your
You
Honor.
need to be calling those mortgage companies every day, Mr. Sowards. They need to move on this like real quick. We need to have some definitive movement and payment on that by the June 27th.
Yeah,
So
yes,
of
Your
course,
Honor.
not satisfied. The risk is, of course, going to appoint a receiver.
If I can show you an approval by that date, will that be sufficient to proceed in that?
I'm not going to commit to that right now, Mr. Sowards.
Okay,
Approval that you may close in 4 months or after. You have a delinquent significant obligations that need to be addressed. So maybe reach out to other family members or friends. Maybe you can secure some other financing of other means so you can pay these obligations.
yes, Your Honor, and was part of the marital debt that I was required to pay as part of the judgment.
Keep on with the refinancing, but also reach out to realtors. Get realtors and have your fair market analysis. You need to work both tracks at this time, Mr. Sowards.
Yes, Your Honor.
All right, that will conclude this hearing. You can all zoom out. Have a good rest of the day.
Thank you.
Your Honor.
Welcome.
Thank you.
What about the apostille?
Part of the recommendation.
Ms. Sowards will provide that.
Yes, we will.
Again,
Okay, all right, you can zoom out.
Thank you, Your Honor.
thank you.
Mr. Sowards is present. Good morning, everyone.
Good morning.
Good morning, Your Honor.
The parties have conferred with Mr. Walker this morning from the front of the court. Let me share with you his recommendation. The recommendation is that the West Newburgh be listed for sale on before July 5. Defendant shall provide a copy listing and give it to plaintiff's attorney immediately. Defendant shall provide photographs of every room in the house where the children will be staying to plaintiff's attorney on or before July 1st, 2024. And the parties will appear back for his court for review hearing regarding the sale of that property on August 7th, 2024 at 9 a.m. That is the recommendation. First recollection that the listing of the property was previously ordered back in May.
It was, Your Honor, and my client has actively proceeded with that. He's had realtors out, selected a realtor, signed an agreement with the realtor, and now the realtor had recommended that he get a lot of things moved before they post pictures and post it on the multi-list in mid-July. Mr. Walker's, after listening to everybody, said move that up. That particular property has no debt and will satisfy all the amounts overdue to Ms. Sowards, and the realtor expects a quick sale.
Okay, this recommendation, of course, to deal with just one parcel. What about the other parcel? Is that listed?
That is not. That has substantial debt and would not satisfy the amounts due. My client does use it as a home. It's going to be the home the kids are going to be staying at when they come here in next week. So we would be hopeful the court, unless there's some unreasonable delay in the sale of, as the court hold on that, because it's simply, once you add in closing costs and everything else, is going to get very little out of that home.
Thank you. So you're asking that the court adopt the recommendation, Mr. Petrangelo?
I am, Your Honor.
All right, thank you. Ms. Sikorsky?
Judge, everything that you and Mr. Petrangelo have stated is also my understanding, and my client has no objection to the court adopting Mr. Walker's recommendation. I do still have the outstanding issue of my attorney fees that can be addressed down the road after we get the property sold. And of course, if the court reserves the issue of having to list the other property pending Mr. Sowards' compliance with the previous orders, I'm fine.
Noted for the record, Ms. Sikorsky.
Thank you.
The counsel, do you wish to voir dire your respective clients? Obviously, they participated in the discussions this morning.
I believe that'd be best.
All right, Mr. Sowards, can you both raise your right hand to be sworn? Thank you. All right, Mr. Petrangelo, if you're going to give us Mr. Sowards.
Mr. Sowards, you've heard the recommendation today.
Can you repeat the question, please?
Have you heard the recommendation placed on the record?
Yes.
Now, you know, there's a lot of variations in this, and the judge could have independently reached a decision more favorable to your ex-wife or to you. With that understanding, are you willing to accept Mr. Walker's recommendation today?
Yes, sir.
All right, nothing further.
Thank you. Ms. Zagorski, do you have any questions of Mr. Sowards?
I do not.
Any questions for Ms. Ashley?
Just briefly, Ashley, will you state your name for the record?
Ashley Swords.
And similarly, you heard the agreement?
Yep.
And do you believe it's the best path forward at this time?
Yes.
Okay, thank you. That's all I have, Judge.
Mr. Petrangelo, do you have any questions of Ms. Sowards?
I do not, Your Honor.
Very well. Thank you, Ms. Zagorski and Mr. Petrangelo. Mr. Walker, the court will adopt the recommendation. We'll see everyone on August 7th at 9 a.m.
Thank you, Your Honor.
Thank you, Your
You're
Honor.
welcome. Have a good rest of the day.
You too.
Thank you, Your Honor.
Morning, Your Honor.
When we were last in court on June 27th, the court entered an order that the property notice should be listed for sale on before July 5. Defendant will provide a copy of the listing agreement to plaintiff's attorney immediately, and defendant will provide photographs of every room in the house where the children will be staying prior to July 1st, and the review hearing will be scheduled for today. The parties have conferred with Ms. LaPrade this morning, who has provided the court the final recommendation, knowing that the house is not currently listed for sale, and that the receiver be appointed to forthwith sell both properties. That is in order so that the defendant can pay settlement payments to the plaintiff per the judgment of divorce. That's the recommendation. Mr. Petrangelo.
Your Honor, first of all, as to the sending the pictures, we did that. The children did come. They did have their visit. It was the first time in 3 years. My client's thankful all of that was able to occur. Appreciate everybody's involvement in that. As to the home, he did sign a listing agreement. The realtor is the realtor who they used when they first bought the property. He is with a firm, a reputable firm, and I believe Ms. Sowers knows that. That's not the issue. She's not getting her full support and her other money, and I understand that. We got the realtor on the line. Essentially, and I'm paraphrasing what I heard, is that his opinion is that there were some major things to get done before this could be effectively sold, and not taking the time to get that done first could delay actually getting this marketed and sold. This is a property that had numerous trailers, dumpsters, junk, water issues, all of these things. He has a date set up next Tuesday to come out and take photos, to now post it on the multi-list, and he confirmed that. His expectation is the property, if that's all done as he's directed, should sell quickly. Now, this case is scheduled to come back on August 28th at 8:30 on an objection filed by Ms. Zagorski anyway. I am requesting that the court delay appointing a receiver or consideration of that until that date. As much as I understand the need to get these things paid, we've got numerous photos showing an enormous amount of work that's being done, and people have come out as volunteers to help Mr. Sowards get this property cleared. This is not me asking for 6 months. I think we'll see we'll have a much clearer idea where we are in just 3 weeks. So with that, I don't see a receiver working much faster than that, really, in the effect of getting the property sold. So that my client, I think, thought there were going to be buyers coming out. The realtor explained that he has other realtors who'll come take a look also, and my client viewed that as a showing coming up. That's not a showing in terms of buyers, but it is clear that people who they're going to have a good view as to how marketable this is to sell, and that's the point of it. And that's I think that's a sound plan of action and not an exorbitant period of time in consideration.
What is the nature of the objection hearing on August 28th at 8:30? The court was not aware of that.
I'll address that. Thank you, Mr. Petrangelo. It's my objection. Your Honor, Mr. McKee had Mr. Sowards on his show cause docket, and Mr. McKee was adjourning. And the last time he adjourned based on Mr. Sowards' representations that he was selling this house and would be able to pay his arrears. Mr. Sowards is over $16,000 in arrears on his child support. I objected to Mr. McKee's recommendation, and so that show cause is now on your docket with Attorney Hicks. That's what's on for the 28th, is the show cause.
Is it on this court's docket?
Yes, I coordinated with Attorney Hicks. In fact, I reached out to her this morning. She explained that I was to put it on your docket. I provided her with a notice of the hearing and Mr. Petrangelo and Zoom instructions to you, and she said she would pick it up from there.
Thank you. And obviously, Mr. Zagorski, you're asking the court to appoint a receiver forthwith, correct?
Judge, I don't know what else to do. I filed my motion to sell this property in March. That was 5 months ago. Mr. Sowards has known of his obligations in the December judgment since they were negotiated last fall. You know, he now owes her $108,920.59 and he's not paying his support. He's not meeting his obligations. He said he was ordered to list the house by July 5th, and he didn't do that. He's not following any of your orders, and I don't know what else to do. He shows up today, and he wants more time, and he wants more time, and he wants more time. Time is up. You've already ordered this.
Court recognized that. Mr. Petrangelo, again, what needs to be done on this property? Just a junk needs to be removed, or does there need to be some repairs made?
All of those things, Your Honor. There was water in the basement. There needed to be repairs there. There's these two parcels had been treated as one, and things all they're involved. He's provided me photos of these huge pillars, fencing being pulled out, of people emptying out these shipping containers on the property. This was scrap metal and things was part of his occupation, and this was used as a storage area. So there, he has provided me with photos showing a great deal of activity and others helping him. Mr. Piper, the realtor, did acknowledge a lot had to be done and needs to be done. I think this is an issue of, we got a realtor, he signed the agreement. He's trying to do what the realtor tells him will sell it fastest and most effectively, and we're on track in just next week to put it on, have the photos and put it on the multi-list at that point. So whether Mr. Sowards should have done it faster than that, when we're down to days, I think taking an extra step of a receiver is not necessary.
If I may, Judge.
Ms. Zagorski, have you received a copy of the listing agreement?
I did, Judge. The listing agreement existed the last time we were in court. That was done before. That's not some step that he's taken. And I always appreciate maximizing the sales price of something, but we're doing it at the expense of my client. She's already owed that $108,000. Mr. Sowards is buying time so that he can get more money. I don't care, with all due respect, about the profit that Mr. Sowards makes. My client's entitled to her money and has been for months.
All right, the court, we're going to give Mr. Sowards one last opportunity. The court's going to adjourn this matter to August 28th at 8:30. And the court's going to order Mr. Sowards personally appear that morning. Mr. Sowards, unless you made a significant payment toward your child support arrearages, there's a real good chance we're going to start contempt proceedings that morning. So you're to personally appear the morning of August 28th at 8:30, fourth floor of the courthouse. Mr. Petrangelo, you can appear personally if you wish, or you can appear via Zoom, but Mr. Sowards ordered to personally appear because we're going to proceed with contempt for fair paid child support. And at that time, if the property's not been listed on the multi-list, the court will in fact appoint a receiver. I can guarantee you that. So don't wait till the August 27th to do this, Mr. Sowards. Get it done.
Yes, Your Honor. I am actively doing that as quickly as possible. And
It's not quick enough, sir. It's been 5 months, and month after month after month delay. So this is your last delay, Mr. Sowards. You're digging a deep hole for yourself, and you can, the realtor can sell it while you're sitting in the county jail. So it's adjourned to August 28th at 8:30, the last adjournment. And the court will appoint, in fact, a receiver on that date. Ms. Gorski, maybe you can, I don't know who you propose. I know Attorney Godfrey has acted as a receiver in the past. Maybe Billy Jeffers may be a good candidate, but the court will, in fact, appoint a local attorney to act as receiver. And that will, of course, reduce any net proceeds of the sale, Mr. Sowards. So just so you're aware of that. And if you don't make some, if you need to come up with some cash payments to the front of the court between now and then, your child support.
Yes, Your Honor, I understand. And I just
I will conclude this hearing.
first actively trying to finance it because I knew the sale would be a large project.
You need to borrow some money from family and friends, Mr. Sowards. We can't wait till the sale of this property for you to pay child support.
Yes,
One
Your
may be thinking in terms of property settlement payments, but child support needs to be paid.
I will do that,
So
Your
the
Honor.
court will, in fact, start contempt proceedings on August 28th at 8:30. We'll appoint an attorney to represent you if Mr. Petrangelo doesn't represent you on the contempt. All right, the court, Mr. Pratt, if you could modify the recommendation, please. We'll serve on then August 28th at 8:30.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, the updated recommendation's already in your queue.
Thank you, Mr. Pratt. Conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff Ashley Sowards, and Ms. Sowards is present. In addition, Attorney James Petrangelo is present, and the defendant Adam Sowards is present personally here in court as directed by this court for possible contempt proceedings. The parties have conferred this morning with Mr. Pratt from the front of the court. The court there's nothing in the court's queue yet, Mr. Pratt.
Yes, sir.
Recommendation.
Your Honor, there is going to end up being 3 different recommendations that are going to be in the queue. One is going to be a motion rec, one is going to be a de novo, and then after we complete the show cause, I will upload a show cause order for you to sign.
Okay.
They should be in your queue now. I apologize.
Yes, one is now in the queue. Noting that the home has been listed for sale, presuming that is 6-2. Is that correct, Mr. Petrangelo?
It is, Your Honor.
And the other parcel had been previously listed, correct?
No, the other is not listed. The other is basically mortgaged to the point there'd be nothing generated. I did provide a report from the realtor to Ms. LaPrade and Ms. Zagorski. I can briefly recap for you as to the situation.
Well, it's also noted, I'm sorry, Mr. Petrangelo, that Mr. Sowards shall accept, it's recommended he shall accept the offer that's been received. So in other words, home has been listed, it's been added to the multi-list, and he's already received an offer, is that correct?
That is correct.
Is he inclined to accept that offer?
His realtor has another open house. He had one last weekend, and he has another one scheduled for this Sunday. The issue with this offer is it's a very low down payment with a closing by September 30th. And so doesn't appear as the strongest candidate to get through. It doesn't mean he won't. For that reason, the realtor said, he said at the last open house, he had 10 buyers come through, most with agents. He said the best bet for everybody to get this done, and I spoke to him, heard him over the phone too, he would recommend he be allowed to have the open house on Sunday and give Mr. Sowards until Tuesday to accept the best offer. He said, however, if this buyer is going to bolt, I'll tell him and he can accept this at that time. So that's our situation. His report goes on to talk about all the work he did to get this in a marketable state, and that he said he's done an excellent job. And so we have a lot of interest, and it's actively being worked on. And the offer, if it goes through, will take care of everything and then some. It's just obviously if somebody comes in with 20% down or some stronger ability, we know that Ms. Sowards is going to be more certain that she's going to get her money.
So this is a cash offer though, correct?
No, his offer is contingent on him being able to get a new mortgage with a 3% down payment. At least that's the way I read it. I did forward that offer as
When
well.
does the offer expire?
It does not, in my reading, contain an expiration date. And it was made just this week. So I don't, in my reading, I don't see a date that says it expires at a particular time. The realtor's in communication with this other realtor, says the buyer has limited resources to push this too much. I just would hate to, in real estate, what could happen, this guy doesn't get his mortgage and can't close. And then we're trying to move to somebody else. I think if the realtor, it sounds like he's describing a very active situation, a few days to accept seems reasonable and most designed to make sure Ms. Sowards gets her money. I think under this offer, it's to be closed by September 30th. I'm going to ask that the court consider with any other requirements you have that we put this over until after that date.
There's an open house this weekend.
Yes, June 1st.
Okay.
And I believe that shows up on one of the Zillow or other listings as well. I saw that yesterday when I was checking the sites.
Just wondering if the realtor can market this as give us your highest and best offer. Market in that frame that so people know that if they are interested, they need to do their offer, make their best offer on September 1st or that day.
And I told him if you give him a few days, it's going to be, Mr. Sowards is going to have to accept any offer on the table at that point. And so he's got these people, as I said, he's put in writing that he had that many people going through and interested. It does seem like work is going on here to actively try to get this quickly sold.
Right. And we were last before the requirements were transferred on August 7th. Is that correct?
Yes.
It took Mr. Sowards, 19 days to sign a listing agreement?
No. Apparently, and part of this letter is, for lack of a better word, there was more or less a junkyard going on the property and the outback areas and disrepairs. And frankly, the realtor said to him, if you want to sell this, you got to get this stuff out before I post any pictures. And so his letter says, the property held significant personal content, which he's been working to clear out, including large vehicles, storage trailers, business inventory. Based on the timeline, he's done an excellent job of clearing those out, removing items in the yard to prepare for photos. There was a large amount of work required to get the property market ready. He also worked through a significant list of primarily minor cosmetic repairs to the property, repairing siding, updating flooring, organizing, and cleaning. So then professional photos and drone shots were completed on Saturday, August 24th, and added to the MLS. So I think this realtor knows he's got a segment that's interested in this kind of property, and he's trying to make it as marketable as possible.
Right, thank you. Ms. Zagorski.
Yeah, Judge, first and foremost, my client doesn't have any obligation to maximize the profit to Mr. Sowards. Mr. Sowards has an obligation now that is months overdue. So he's had an offer, and we think it should be accepted. Mr. Sowards, this was a 10-acre parcel that my client quitclaimed to him pursuant to their judgment. Mr. Sowards has taken it upon himself to make this a 2.68 acre parcel. He had it resurveyed, and what he is selling is less than what my client gave him for this settlement, for which he has not paid. He took he's keeping the pond. He took the pond off of the property, and my client does not believe that there were significant amounts of items outdoors. She will acknowledge that there were a lot of things indoors, which the photos appear to show that he has removed. But this went on the MLS 2 days ago. 2 days ago. And he immediately got an offer, and we think it should be accepted so that my client can be paid.
All right, the court obviously has been informed that the current offer does not have an expiration as to a time frame. So the court does not see any harm to anyone to give Mr. Sowers an opportunity to conduct this open house scheduled for September 1st. It's right around the corner, and we can come back and review this. And if he's not received a better offer by then the court's inclined to order that he accept this offer when we come back. So the court's inclined to put this over for a week. Perhaps let's see if we have time for available on Wednesday of next week.
I can be available.
I'm sorry. Courts is nothing available on Wednesday, perhaps on Thursday.
I have Thursday morning, I'm available.
Right. Ms. Nancy, do we have someone on Thursday morning?
I'm in mediation with Ms. LaPrade, but I can step out, I guess, for a minute.
Okay. I'm sorry, the court has a full day trial on September 5, that Thursday. All right, the court will, at this point in time, the court will reserve any decision on the current offer, and the court will simply adjourn this matter to September 3rd at 2 p.m. So, Mr. Pratt, if you could just revise your recommendation in that regard.
Yes, sir.
And then finally, and then perhaps the realtor, and I don't know if you have contact with the realtor or Mr. Sowers is here, you can communicate with the realtor. She needs to market this as give us your final and best offer, because we're going to accept an offer next week. So sometimes I know some communities, like real estate areas like Royal Oak, those realtors market the property as give us your final and best offer by a specific date. Maybe that they provide that by Monday, 5 o'clock or something, or Tuesday morning before we come back to court, the final and best offer. That's his court suggestion. I'll leave that to you, Mr. Petrangelo, and Mr. Sowers, to relay that to the realtor, that suggestion. With respect to the other issues, the courts received a de novo order that the referee recommend order be rescinded and canceled for an enforcement order dated August 28th, 2024. Mr. LaPrade, that had to do with child support, is that correct?
That is correct, Your Honor. It is it was before referee McKee. He requested to adjourn the matter or recommended to adjourn the matter to August 7th. That date has passed, so we are requesting to rescind, but we would like to proceed with the show cause.
With contempt, is that correct?
That is correct, Your Honor.
What are the current support arrearages?
Current arrears balance is $14,629.50.
Right. What was the last payment made by Mr. Sowers?
Mr. Sowers made a payment yesterday of $1,800. That payment has not dispersed yet, but that payment was made. This has been pending for quite a while. Referee McKee recommended the adjournment for the home to be listed. As we know, that has been delayed as well. There were no payments made during the month of July. Mr. Sowers did state he did have income in the month of July. He didn't have an exact dollar figure, but friend of the court is requesting we proceed with contempt. Thank
you. The $800 that was made online, is that correct?
It was made here at the window. It just takes a day to disperse, Your Honor.
Okay, what is the cash payment though, correct?
That is correct.
Right,
but that's not included in that arrears balance, Your Honor. That was an August payment.
The court's aware that an online payment can be revoked.
That's correct.
So it's verify it's a cash payment.
Yes, sir.
Mr. Petrangelo, have you an opportunity to discuss with Mr. Sowers contempt proceedings?
Yes, Your Honor. What I would tell you, first of all, is that $1,800 plus the amount he paid early in the month of another $700 meant that he made a full month's support payment this month. Of course, that's not July, that's August, but my client is very mindful of the fact he's overdue in this obligation and of Ms. Sowers and the children's needs. He very much is. He asked that the court consider in determining his ability in this situation. He had all of the expenses to get this property on the market to sell. He also, in the past few months, has had numerous debts, including, he said it's about $12,000 in taxes, I think is a new thing, or a number he threw out, including property taxes on this earlier this summer, to make sure this did not go on tax sale. And so the money he's had, he's been scrambling to cover all of these things to make sure this property is available and marketed. And as one other thing, which isn't normally a factor, we had negotiated quite some time ago for, in the end, 6 children to be flown here for the month of July. And that was their first visit with Dad in 3 years. And as part of that, Mom had a list of, or some things she wanted to be sure were taken care of before they stayed in the house. So he's had a lot he's scrambling around to put together. It doesn't delete the amount due and the need, but it also shows he's not just sitting around blowing all this off. This man is hustling, trying to get us across the finish line right now. I'd ask you to consider delaying or reserving a decision on this at this time.
Thank you. Obviously, if Mr. Sowards cannot afford the child support order, he's got to file a motion to reduce the support obligation. He just can't sit on his hands. The court would also note that the Attorney General generally gets cases in which the arrearages exceed $10,000 catch the attention of the State Attorney General, and they'll charge him with a felony charge of felony non-support. So what the court would like to do is secure a contempt finding today, but the court's inclined to reserve sentencing on that contempt. In other words, Mr. Sowards would be holding that key to jail, and if he does not address this obligation in a timely fashion, then he'll be putting himself in jail. So with that, the court's position on that, Mr. Petrangelo, does he want to present some testimony this morning from the front of the court, or is he willing to admit to contempt?
Your Honor, I believe my client would just not contest the finding at this point because of the amount, not the work he's been doing recently.
Right. Mr. Sowards, you understand that if you're found in contempt for failure to comply with an order of this court regarding child support, you could be ordered up to 45 days in jail. Okay. You discussed all these matters with Mr. Petrangelo, is that correct? And are you willing to admit to contempt this morning? The court is inclined to reserve sentencing, which means you got 45 days on your head, and you're going to hold the key to that jail. All right, raise your right hand to be sworn. Do you solemnly swear affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Please state your name for the record.
Adam Watson Swords.
Mr. Swords, do you admit and acknowledge you're obligated to pay child support for the support and maintenance of the children born to you and Ashley Swords?
Yes, sir.
Do you admit and acknowledge that prior to yesterday's payment of $1,800, you had arrearages in excess of $14,000? You admit and acknowledge you paid nothing, not even $1 in the month of July of 2024. Mr. Petrangelo, do you have any questions, Mr. Swords?
Under these circumstances, I don't, Your Honor.
Right. Ms. Gorski, do you have any questions, Mr. Swords, regarding the contempt finding?
No, thank you, Judge.
Ms. LaPrade, do you have any questions, Mr. Swords?
No, I do not at this time, Your Honor.
Very well. Based upon the testimony of Mr. Swords, as well as a review of the records contained in the court file, the court finds Mr. Swords to be in contempt of court for failure to pay child support as ordered. The court, however, will reserve sentencing in that contempt. Actually, the court will order that he serve 45 days in jail, but that 45-day sentence is reserved at this time, Mr. Swords. You have 45 days in your head. So you're on a fine line to spend some time in jail. If you do not take care of this obligation, you need to look at selling some other assets and change your lifestyle, because it's got your first priority is child support once you pay these sums due to Ms. Swords. And again, there's about $180,000 some dollars due to Ms. Swords, and nothing's been paid on those obligations as of this date. Is that correct?
Judge,
The amount owed for the property settlement is $108,920.59. He also owes over $14,600 in child support, and that amount does include the $1,800 he paid yesterday. Until yesterday, it was over $16,000.
The property settlement's about 108,000?
Yes.
Yes.
Okay,
There's another 80,000, but that's not due until 2027.
There's also 18,000 for the business portion, I believe.
That's included. That was supposed to be paid in March.
all right. So as of the date, it's about 108,700 some dollars due for the property settlement. Is that correct? And hopefully
Yes.
that can be paid out of the sale of the proceeds from the real estate.
Yes.
That will certainly assist. So, Mr. Pratt, perhaps to the rec, you can just simply add that Mr. Sowers is found in contempt. 45-day sentence is reserved at this point in time, and the matter will be adjourned.
Your Honor, front of the court would request remove this to Ms. Hicks' docket October 1st at 8 a.m. to make sure that September payment is made. That would be the request on the show cause.
Very well, so ordered.
Thank you, Your Honor.
And we'll put this back in our docket for Tuesday, September 3rd at 2 o'clock. Anything further this morning, Mrs. Zagorski or Mr. Petrangelo?
No,
No,
thank you.
Your Honor.
Right,
Is,
all right, thank
is
you, Mr.
that
Pratt, for your assistance this morning. I'm sorry, go ahead.
your, October 3rd is a Thursday? Is it?
October 1 is the show
October.
cause. September 3rd is to monitor the open house, Mr. Petrangelo,
Okay.
just to clarify those dates.
October 1 at 2 o'clock is the show cause docket.
October 1 at 8 a.m. And then Judge said September 3rd was 2 o'clock or 3 o'clock, Your Honor?
2 o'clock.
Thank you. Let me get that corrected for you. I thought I heard 3. Thank you.
And obviously, if Mr. Sowers has made payments between now and then, Ms. Six will not bring him before the court. If he's paid nothing, Ms. Six will probably bring him before the court later that morning, Mr. Petrangelo, for us in
Understood.
jail.
Understood.
Okay, all right, that will conclude this hearing. We can zoom out. Mr. Swords, you're all set to go. Talk with the realtor and have the realtor make it clear to potential buyers that submit their final best offers by Sunday or Monday,
I'll do exactly.
so that they know that you are a very interested seller. All right, that will conclude this. Good afternoon, everyone.
Afternoon, Your Honor.
Court has received the fine recommendation from Mr. Pratt. The court is pleased to note that an offer to purchase the property and sell the property in question has been accepted, and the buyer has until September 30th, 2024, in which to close. It's further noted that Ms. Swords will receive $108,920.59, which will pay in full the property sale amounts due to her through today. All other matters are reserved for mediation with Mr. Godfrey. Further, Mr. Swords will receive a $400 credit for agreeing to pay Ms. Swords one half of mediation fees. Ms. Sikorsky, is this recommendation agreeable with your client this afternoon?
It is, Your Honor. Thank you.
Thank you. Mr. Petrangelo?
Yes, Your Honor.
Okay, and you've got a copy of the accepted offer, Ms. Zagorski?
Yes.
Okay.
It was forwarded to Mr. Petrangelo. He sent it to me and I've shared it with my client now.
Are there contingencies?
It's the offer that he received last week. It's the one that requires the buyer to get a mortgage. So hopefully that all moves forward. It's expected to close by the end of the month.
Okay. What else needs to be mediated with Mr. Godfrey?
It was originally scheduled for September 23rd to talk about Mr. Sowers' holiday parenting time. We've agreed that we're also going to address my request for attorney fees for this underlying property issue and future amounts owed. And then we're back before you on Ms. Hicks' docket for the child support show cause on October 1st.
Your mediation with Godfrey is September 23rd?
Yes.
Okay. Well, you can always zoom in here if in fact you want to put something on the record on the 23rd.
Thank you, Judge.
Thank you.
So it won't be in our calendar. What time's your mediation with Godfrey on that date?
We
10
start at 10 o'clock,
I'm sorry?
10 a.m. because of my
10 a.m.
client's time difference. Yes. So we're starting a little
I
bit
gotcha.
late.
All right. Well, we can pull the file and have it up here that day, September 23rd.
Thank
All right. Mr. Gorski or Mr. Chandra, either way, you want your clients sworn so you can voir dire them regarding this recommendation this afternoon?
I don't need to. Thank you.
You're fine as well, Mr. Gentile? Okay. Very well. Court will adopt the agreement to reach by the parties to enter the order presented by Ms. LaPrade. And let's keep our fingers crossed that transaction closes.
Yes.
Yes.
All right, that will conclude this hearing. Now we can zoom out. Have the rest of the day.
Thank you, Judge.
Thank you.
And the plaintiff's motion for custody and parenting time and other relief. This hearing is being conducted via Zoom. The President is Attorney Ronald Bruce, representing the plaintiff, Emily Ackley. Is Miss Ackley present in your office, Mr. Bruce?
She's on Zoom, Judge. I think it says Emily on my screen.
Right, Miss Ackley, are you present on audio?
Yes, sir.
Oh, sorry.
Emily Ackley present?
Yes, sir.
Good afternoon. And also defendant father, Kevin Ackley is also present. The matter is also before the court for a pretrial conference. Parties have conferred with Ms. LaPrade. This afternoon, Ms. LaPrade is recommending that the court enter an order that mother have supervised parenting time and family counseling shelter services. And the parties shall mediate with Mr. Walker on July 15th, 2024, 1:30 p.m. Ms. LaPrade, could you add something to this recommendation that the parties appear for a continued pretrial conference immediately following that mediation, please?
Yes, sir.
Thank you. All right, is this recommendation agreeable with your client, Mr. Bruce?
Yes, Judge.
All right, Ms. Ackley, do you understand the recommendation?
Yes, I do.
Okay, do you have any objection to the court adopting this recommendation?
No, I do not.
Okay, a couple of issues. When we were last before the court, March 13th, when the matter was adjourned to today's date, Mr. Bruce, I think Mr. Ackley, your client, advised the court that the parental rights of Ms. Ackley have been terminated by a court from another jurisdiction. You're to provide documentation of those orders.
Judge, I think Mr. Ackley was to provide that. I don't believe her rights were terminated.
Okay, hold on. Okay, oh, that's right. I'm sorry. You represent Ms. Ackley.
Right.
Mr. Bruce, are you aware of any such court orders that terminated your client's parental rights?
No, Judge, she was unaware of that. She currently has a DHS worker. They indicated that her rights weren't terminated for what that's worth, but she never participated in a termination proceeding.
Mr. Ackley, you were to provide documentation. You made allegations, but there's no court orders to support your allegations.
Yeah, I tried to go to Washtenaw County a couple times to the courthouse, and they were supposed to email me anything that they found. They could only give me documentation of me winning back my kids. They couldn't give me anything on Emily because the documents were classified and our court proceedings were separated for the little bit that Emily had gone to the court.
Okay, what type of action was this Washtenaw County? Was it a divorce action? Was it a neglect case? Probate court?
The kids were in foster care.
Okay. Well, what you need to do is get in the car and drive up to Washtenaw County. They generally won't just email you the pleadings. You got to go up there and actually look at the file and generally pay a small fee for copies of documents. So that's your obligation, Mr. Ackley. But so without documentation, there's nothing to support your allegation that her parental rights have been terminated. So the court will permit. I understand she's not had contact with the children in some time, so it appears that this recommendation is appropriate. That she have supervised parenting time. You both need to call that agency. The phone number is on this order. Call them and schedule an intake. There's a fee for each of you to do the intake, and then they get on that waiting list. You both need to call this week. You both have the phone number. If not, get a piece of paper and pen. Write this down. 241-0180. Need to call there today or latest tomorrow morning. 241-0180. It's area code 734. Tell them that the court in Monroe has entered an order for supervised parenting time for mom, and you need to schedule an intake. Did you capture that number, Mr. Ackley?
Yes, I did.
Are you going to do it? And Ms. Ackley, you got the phone number as well?
Yes, I do.
Okay, and the other issue, Mr. Bruce, I believe you informed the court that was Ms. Ackley, is she currently pregnant, or did she deliver a child while the parties were separated? I don't recall.
Delivered a child while the parties were separated. We did talk about that in mediation. I'm going to coordinate a DNA test with Mr. Ackley to confirm he's not the father.
Okay. How old is this child?
6 months, I want to say, Miss Ackley. Is that accurate?
She is almost 3 months old.
3 months.
Okay, child born out of wedlock. 3 years. Mr. Ackley denies he's the father. Is that correct?
Yeah.
Okay, so Mr. Bruce, I suppose you could get a paternity test between Miss Ackley and the alleged bio dad. And if that established paternity, the court could then revoke paternity as to Kevin.
Judge, I believe the biological father is currently incarcerated, so I don't think I can get that DNA test.
Well, most prison facilities have the capability of doing will have someone allowed to do DNA testing.
I can check with the facility.
Where's the end?
I'm sorry. I was actually wondering if it would be okay if I had her father sign an affidavit of parentage and get it notarized. Would that be all right?
I know, Miss LePrad, will they allow, is that permissible after generally that's done at the time of the delivery at the hospital?
Actually, Your Honor, it's not, because the affidavit of parentage specifically says that the mother is not married. So that form would probably not be proper.
Thank you. Do you understand, Miss Ackley? So that's only if you're not married. So the only way you can do this is for DNA testing. Where is the father's child? Where's he incarcerated?
He is in Macomb County. Well, no, actually he was in Macomb County and I'm not sure where they moved him to. I would have to get back to you with that.
Well, let your attorney know, and Mr. Bruce, you can perhaps make inquiry, find out what facility is located and whether or not they'll allow someone to come into the facility for the con swab DNA testing. Or maybe you can find his out date. I mean, obviously he's in a county jail as opposed to prison. Is that correct, Miss Ackley?
No, he is in prison.
Okay, somewhere in Macomb County. All right. Do you have any idea of his out date?
Oh, yes, I do. He'll be out in about a year. I do have regular contact with him about Kyla. I just forgot the name of that they moved him to.
All right. So he's obviously not going to be out within the next 3 to 6 months, Mr. Bruce. So perhaps Ms. Ackley can assist you in determining the location of the alleged bio dad. You can make inquiry as to whether or not they'll permit DNA testing.
Okay.
All right. Is there anything further this afternoon, Mr. Bruce?
No, Judge. I think that's it.
For the purpose of mediation, is there anything at issue? I mean, the parties have been separated since 2017. They lived together as husband and wife for 2 years. Is there any real estate?
No, Judge. Just figuring out the paternity and getting mom some organized parenting time. That's about the only issues.
Well, those can be done post-judgment as well. Mr. Ackley, would you agree there's nothing at issue in terms of divorce? You already divided your personal property?
Nah, there's nothing at issue. There's nothing to separate.
Okay. The only issue is being custody and parenting time.
What?
And paternity of this unborn child or of this child born out of wedlock. Right, to Mr. Ackley, you'll be mailed the copies order. Make sure you mark on your calendar mediation, the Zoom mediation with Mr. Walker. Will provide you with a Zoom ID number July 15th at 1:30, and then subsequently appearing before this court for a continued pretrial conference. And Mr. Bruce, hopefully you can explore the DNA testing in the state prison where the alleged bio dad is incarcerated.
Will do.
Okay, Mr. Ackley, do you have any questions?
No.
Okay, all right, and let's make sure we still have your address, Mr. Ackley. You're still at 1?
Yes.
Okay. All right, that'll conclude this matter. Thank you, Mr. Bruce. Mr. Ackley can, Ms. Ackley can zoom out. See you after the mediation of July. For the record, this matter is before the court for a continued pretrial conference. This hearing is being conducted via Zoom. President is Attorney Ronald Bruce, representing the plaintiff, Emily Ackley. Ms. Ackley, you are present audio. Is that correct, ma'am?
Yes, sir.
And defendant Kevin Ackley is also present. Good afternoon, everyone.
Good afternoon.
Good afternoon, Judge.
If the court recalls, the primary issue was that of paternity or revocation of paternity. Is that correct, Mr. Bruce?
That and supervising parenting time for my client.
Correct. The last order of this court, May 22nd, mother had supervised parenting time at Family Counseling Shelter Services. Our last before the court, though, issues were custody and parenting time. So the parties really made no progress then today. Is that correct?
No,
Well, it's my understanding, Judge, that Mr. Ackley is still alleging that my client's rights were terminated, even though we adjourned it in March for him to provide documentation in regards to that. So I don't believe he's willing to agree to anything related to parent.
Well, have you investigated, Mr. Bruce? Has there been an order entered by some court in some other jurisdiction that
I didn't find
terminates
any in
mothers'
Washtenaw
parental
County.
rights? I'm sorry?
I looked at Washtenaw County. I didn't see anything. All I saw was there was a motion, there was a termination proceeding filed against both parties. Dad apparently was given the kids and the case was closed, but my client's rights were never terminated. I think that's what happened. Dad insists that my client's rights were terminated.
Okay, so I'm sorry, you do have a copy of this, was it Lenawee County order? You have a copy of that?
I thought it was Washtenaw. I went online and I have a
Right.
screenshot.
So do you have a copy of that order from the termination proceedings?
I have a screenshot, I think, of it, but I went online and looked and I didn't see anything.
I'm having a real hard time catching everything, Mr. Bruce. It's very echoey, and I'm sorry, I don't know if it's our system or if it's your system, but maybe getting a little closer, it might be a little clearer. I was having a real hard time catching everything.
I don't have a copy of the order. I have a screenshot from my client. I went online and confirmed it with the, the information that they have available. I didn't see anything else with my client's name on it, which I think there would be a termination trial, which there never was, at least that I didn't see.
Mr. Ackley, do you have a copy of a court order that terminates the plaintiff mother's parental rights?
as of right now, I've tried to get that order, and I take care of these kids too much. Like, I work anywhere from 50 to 60 hours a week. And for me, just to get something, like, I tried to turn in something for you to see on Friday, and I was barely able to make it to the courthouse before they closed because I work an hour away from where I have to turn this stuff in. And if this keeps going on, I'm going to have to hire my own lawyer to do my own footwork, because my lawyer, when I hire one, will be able to find that, will be able to prove it. Because if I had a lawyer on the other foot, like Emily, my lawyer would come to the door with the court paperwork. Like, I'm going to work and take care of these kids, and then I have to run over here to different times. I can't just take times off of work. I can't do this. I can't be my own lawyer. I've had one time where I was able to get to Washtenaw, and they're like, that paperwork's so long. Like, here's your last order, but our court dates were separated. So I think it's in Emily's stuff somewhere that states that she doesn't have any rights. And I just turned something into your county clerk stating something to do with this new kid that Emily just had. And I think it's page 2 of 2. It states everything that happened with Emily's first 2 kids and my sons, which she has no rights to any of them. And it states that in that it's not a court order, but it's something from a foster care agency.
Right. Without question, you should hire an attorney, Mr. Ackley. So what the court's going to propose, let's take the proof today. This case is getting old. I'm going to take the proof to establish there's jurisdiction. There's been a breakdown of the marriage, that Ms. Ackley is not now pregnant. And the court's going to reserve all outstanding issues. I think it's a wonderful, great idea for you to get the assistance of an attorney. We get to the bottom of this. Any objection to that, Mr. Bruce?
No, I think you should hire him.
Okay. And we also have, Ms. Bruce, you are going to make inquiry and facilitate DNA testing with the alleged biological dad from state prison, or from prison in Macomb County. Were you able to make any progress in that regard?
I talked to my client, Judge. My understanding is dad is not cooperative, or the presumptive dad, I guess, is not cooperative towards getting the DNAs, and he's in prison.
This child was born during the marriage, correct?
Correct.
All right, so someone's got to file a motion to revoke paternity. Mr. Ackley, on Michigan law, you're the presumed to be the biological father of this, the three-month-old child, because the child was born during the marriage. Probably somebody should have started the divorce a long time ago. If she has another child, you're also presumed to be the father of that child. So you need to have an attorney. The attorney needs to file a motion to revoke paternity.
I got a phone.
You were not the biological father of his child, and then we have to do DNA testing to do that. So this is a very complicated case. You definitely need an attorney, Mr. Ackley. Okay.
I'd received a phone call about 2 weeks ago about somebody sending me a DNA test to take on this kid. I don't know if it was a receptionist from Mr. Bruce's law firm or who it was, but they said Emily was paying for a DNA test and I'd be sent one in the mail.
Ms. Bruce, didn't know anything about that, Mr. Bruce?
I don't think they would have mailed him anything. We probably called because the parties were going to split the cost of the DNA test in Toledo. I think we probably are calling to see if he was still willing to do that. But my understanding is he wasn't.
Excuse me, may I interrupt for a second?
No, you talked to your attorney, Miss. The court's going to take some proofs this morning, and we're going to adjourn the matter so that Mr. Ackley can hire an attorney. Mr. Ackley, for the record, did drop by this morning to the county clerk, and I'm seeing it for the first time. It's a family case plan from the Ohio Department of Job and Family Services. It references the name of Emily Ackley, and it talks about Kylie, the 3-month-old child, would benefit from a developmental assessment. The child apparently is experiencing some issues, Mr. Russo, I'm not sure. I don't know if this is the Ohio equivalent of the Department of Health and Human Services. But it does state in this report, page 2, that Emily lost custody of her older children in Michigan due to mental health and substance abuse issues. There's also been that Emily has been diagnosed with some mental health issues. This agency has concerns about the ability of Emily to safely parent her children and being truthful about her substance abuse and mental health issues. So no, I don't know if the state of Ohio is taking jurisdiction over this child. Do you know anything about that, Mr. Bruce?
No, I have not seen that.
Okay. You may want to ask your client. So it appears that the Lucas County Children's Services is involved. They are performing an assessment.
Is there a date on that?
Yes, it is dated May 16th, 2024.
I mean, I know my client's currently receiving services from their version of DHS.
It suggests that the child is at risk in the care of the plaintiff, your client.
That case, they told me that I am completing case service plans from what I didn't finish with Silas and Kiefer, our sons. So the concerns with the substance abuse and things like that, those were from years ago when we first started the case, the DHS case with Silas and Kiefer. And now they want me to complete those case service plans because I did not. And that case is actually going very well. I can get that information if you guys need it.
Well, it's obviously, I'm not sure what would happen that brought you to the attention of Lucas County Children's Services, but something must have happened, Mr. Bruce. And again, obviously, if the agency is concerned about plaintiff's ability to care for this 3-month-old child, that's obviously relevant to custody of the 2 older children of these parties.
I guess somebody had called from Michigan to inform Ohio that I was having another baby and I didn't complete case service plans up there. So they came to tell me that, I needed to complete my case service plan, which I am now currently doing.
Right. And we're still at the same point we were back in March, Mr. Bruce. We've not moved forward at all. So the court needs assistance of counsel. I can't, I don't have time to investigate, call these agencies, get court orders. So anyway, we're going to take the proofs. We're going to adjourn this. And at some point in time, presumably your client wants to get a divorce. Maybe you can dig into this, Mr. Bruce. Mr. Ackley, you'd be well advised to retain an attorney. That attorney can work with Mr. Bruce and let's uncover some of this stuff. So all it's going to do is, again, and there's no other issues, correct? There's no issues of property, Mr. Bruce, no joint debts. The only issue is custody party time. Well, in this court's opinion, I mean, why can't the parties have joint legal? And joint legal, Mr. and Mrs. Ackley say that if the child needs elective surgery, important decisions, you have to contact and share equally those decisions. So in this court, it's just joint legal and then parenting time. So all we got to do is agree upon parenting time. The children are 8 and 7. Who do they primarily reside with right now?
They have resided with me for the last 7 years.
Okay. Again, I think it's a matter of just to determine parenting time for mom, Mr. Bruce. We don't need to put the label of physical custody, but we can say the dad should be the primary caretaker of the children and establish a parenting time schedule for mom and then address the paternity of this 3-year-old child, and the parties could get divorced.
I don't believe Mr. Ackley is agreeable to any time for my client. That's,
Okay, is Miss Ackley, has she started supervised parenting time at Family County Shelter Services?
she's not.
She's still on the waiting list?
She's has supervised time in Ohio with her other kids. She wanted to know if the court would consider allowing her to have supervised time in Toledo if she can have someone pick up the kids from Mr. Ackley and take them back to Mr. Ackley.
Did you discuss that during the course of mediation this afternoon?
I believe Mr. Walker did bring that to Mr. Ackley's attention.
Okay, was it discussed?
We were in separate breakout rooms, but my understanding was that Mr. Ackley's not agreeable to my client having any parents.
So what's the status with the court entered an order? The mother shall have supervised parenting time here locally, Family County Shelter Services. Has that started? Apparently not.
No, it has not.
Is Miss Ackley on the waiting list?
Yes, I am on the waiting list for that. I was wondering if I could do that supervised parenting there as well as Wednesdays for an hour here when I get supervised parenting time here with Kyla as well.
Did you ask Mr. Ackley about that?
He will not speak to me, and the mediator
Hey,
told
Mr.
me.
Ackley, what about that proposal?
I'm not comfortable with my son's going to anything until the whole issue about her having rights is determined. I brought it up to my sons that they might have to see this woman, and they didn't like it very much, and it made me very uncomfortable. So I'm not okay with it until it's established that she don't have any rights, and then we can just get on with this divorce.
Okay, someone's got to track down orders, Mr. Ackley or Mr. Bruce. The court will continue the order. The prior order is that mother shall have supervised parenting time at Family County Shelter Services, supervised here locally. So once they've got the eligibility, once they, Miss Ackley, you should contact them, see where you're on the waiting list. And once they do that, then yeah, Mr. Ackley would have to take the children to that agency. It'd be a supervised parenting time. And then that agency would provide written reports. It's usually 1 hour a month to Mr. Ackley. So that will continue until this court has an order that mom's parental rights have been terminated. That order will continue. So Mr. Ackley, yes, this court's not going to order for you to have the children go to Ohio. They'll be here locally in Monroe. And Mr. Ackley will drop off the children there and pick them up for your hour of parenting time. All right, Mr. and Mrs. Ackley. We're going to take some proofs. They'll stop the court's clock, and the court we can adjourn this maybe 6 weeks. Mr. Ackley can track down paperwork. Mr. Bruce can track down paperwork. We can do DNA testing. At some point in time, we need to do DNA testing, Mr. Ackley. Are you willing to show the cost of that?
Sure.
Okay, it's about $250 a person. So, Mr. Bruce.
I'm not able to get food stamps or anything right now. I'm paying for formula and everything, my baby out of pocket. I do not have the money right now. I was going to come up with the money on my own, which takes me a lot of extra work. If Kevin was more willing to work with me about parenting.
You can borrow some money, ma'am, unless Mr. Ackley is willing to front that cost. It said Mr. Ackley benefits you considerably because you're right now, this child, you're on the line to support this child until you can DNA testing showing that you're not the biological father of this child.
Right. Which I would go just to get it out of the way. But like, I'm going to have to hire a lawyer, and then I have my own bills at my own house, and then I have my own other kids that I take care of. But I think you said we're going to make this out to be six more weeks. I think I'm going to need probably a little more time than that right now to establish a lawyer. The last lawyer that I had gotten, it cost me $2,000 out of pocket.
Okay. Just so you know, if Miss Ackley has another child, we're further complicating things. Yeah, you both need to move forward with this divorce. Actually, get divorced. So I guess we can make this offer for 8 weeks, but you've got to talk to Mr. Bruce's office, do DNA testing in the meantime. That doesn't happen overnight. You can do that. That's probably your first priority rather than hiring an attorney. Do the DNA testing so that you can determine this child is not your child, Mr. Ackley. Someone's got to file a motion. You got to file a motion. It's called the motion to revoke paternity. Make a note. You got a piece of paper and a pen there?
Motion
to revoke paternity.
To revoke paternity?
Or Mr. Bruce, are you going to file such a motion or not? Someone's got to file a motion.
I'll file it, Judge. I thought there was an agreement he was going to. I'll file the motion.
Okay, but somebody needs to file the motion, get probably before the court. So file the motion, Mr. Bruce, to when indicate the record reflect. Mr. Bruce is going to file a motion to revoke paternity, and Mr. Bruce can reach out to you to schedule DNA testing, even if you got to front the costs. and Mr. Ackley, let's get that done. And Mr. Bruce, you can find out from the front of the court when someone comes to our house, so you can go parties can schedule an appointment with DNA Diagnostics. I think they have a facility in downriver. They come to the Monroe County Courthouse once a month. I don't know if they have an office in Lucas County where your client apparently resides. So get that, and then somebody's got to track down paperwork on this termination of parental rights issue. Any event, Mr. Ackley, can you both please, Bruce, you want to take the proofs from your client, please?
Yes, Judge. Miss Ackley, you recall coming to my office having a complaint for divorce filed in this case, correct?
Miss Ackley?
I'm sorry, what did you say?
Listen, please pay attention.
You came to my office and had me file a complaint for divorce in this case, right?
Yes,
And you lived in the county of Monroe. Dad lives in the county of Monroe for at least 10 days in the state of Michigan for 6 months, correct?
yes,
And at the time you filed, there were 2 minor children, you believe, born between you and your husband, Silas and Kiefer, correct?
yes,
Since then, you had another child, correct?
yes,
You're not currently pregnant, correct?
No.
And would you state that there's been a breakdown in your marriage such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that your marriage can be preserved?
I'm sorry, what did you say? It's kind of hard to hear.
There's been a breakdown in your marriage, correct?
Yes,
And you don't believe that your marriage can be continued, correct?
yes,
And if the judge weren't to grant you a divorce, you wouldn't reconcile and get back together with Mr. Ackley, would you?
no.
I think that covers it, Judge.
All right, thank you. Mr. Ackley, can you please state your name and current mailing address, please?
My name is Kevin Ackley.
Mr. Ackley, did you hear the testimony of your wife Emily this afternoon?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Mr. Bruce, do you have any questions of Mr. Ackley?
No, Judge.
All right, based on the testimony that has been presented this afternoon, as well as plain filed in this case, court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There appears to be no reasonable likelihood that the marriage can be preserved. At this point in time, the court will reserve the outstanding issues, which is basically whether or not the maturity of this 3-month-old child that needs to be addressed, and as well as mother's parenting time. So, Ms. Ackley, you should contact Family Counseling Shelf Services, find out where, make sure you're still on the waiting list, that they haven't lost your name in that waiting list. Hopefully, Mr. Ackley can track down a copy of any order terminating your parental rights. Until the court sees that, the court will assume that she still has parental rights. Mr. Ackley, when was the last time she even saw the children? You're saying she hadn't seen the children in 6 or 7 years?
Yeah. Last time that she's seen them, they're in foster care.
Okay.
No, that is not true. Me and Kevin,
All right, you can talk with your attorney, Ms. Ackley. Again, we're not addressing parenting time today. The court's not going to order anything more than continue the prior order of this court that your parenting time should be supervised at Family Counseling Shelf Services. You've got their phone number. Call them to find out where you're on the waiting list, and they will reach out to Mr. Ackley. Mr. Ackley, have you completed the intake with that agency?
No.
Okay, because the last order of this court is that both of you complete the intakes. You need to call them, just say who you are. They'll just ask you questions over the phone. What's your address, your phone number, and so forth. I'll give you the last order that was contained in the last order of May 22nd, 2024. Do you want their phone number again?
Yes.
It's 734 area code 241
241
0180.
0180. Okay.
Correct. So call and just say who you are. You're there to complete an intake. And that should take care of things. At least then you've done what you've been ordered to do. Finally, let's set another pretrial conference date.
Judge,
the parties can come do the DNA testing in the meantime. So, Mr. Bruce, maybe you can determine where the testing can be done. Mr. Ackley may be willing to front the cost, or just even pay the whole cost if Ms. Ackley is unable to do so. That DNA testing done. So, Mr. Ackley, you're suggesting 2 months?
Yeah, hopefully I'll be able to get something together by 2 months. And can we also do it after 2 o'clock? Normally I work till about 2 o'clock. Sometimes it might be 4.
Sure. Yeah, we can do it later in the afternoon. How about Thursday, September 19th, Mr. Bruce, in the afternoon? Maybe 3 o'clock will work with you, Mr. Ackley?
Yes, Your Honor.
What day, Judge?
Thursday, September 19th at 3 p.m.
Oh, that's fine.
Right, the court will mail out notice of a continued pretrial conference. Thursday, September 19th, 3 p.m. And it'll give you a Zoom once again. Hopefully the parties can make some progress. So Mr. Ackley, you can always reach out to Mr. Bruce and let's get the DNA testing done. There's a firm called DNA Diagnostics. You can Google them. They can tell you where their facilities are. Then both you have to submit. It's just a con swab test, real simple test. But it's a certified testing facility. And let's just add, you have to be tested and the minor child. So Ms. Ackley will have to take the child to this facility. And if you both go to the same facility, it's a lot easier if they collect the sample. Doesn't have to be the same day, but at least same facility. So you may want to go online, just DNA Diagnostics. Mr. Bruce, if you can help in that regard, Mr. Bruce, you're going to follow them and make note you're going to follow the motion to revoke paternity. If you can send a copy of that motion to perhaps to Mr. Ackley along with information how to contact DNA Diagnostics, and the parties can he can maybe determine where he wants to do the testing or what's convenient for your client. Your client lives in Toledo, is that correct?
Right.
I don't know if there's a facility in Toledo, but you can check that out, Mr. Bruce, and give some direction to Mr. Ackley. Hopefully we'll get that done when we come back.
There is.
Okay, any other questions, Mr. Ackley?
No, Your Honor.
All right, that concludes the matter. You can all zoom out. We'll see you on September 19th at 3 p.m.
Thank you.
Stop the clock on that, please. We've done absolutely nothing since we were last here.
Did he even talk to his client?
Okay, the last order of this court, April 3rd, defendant Mr. Humphrey was to cooperate with the completion of the quadro for his accounts. He's responsible for the financial cost of filing that quadro on places retirement accounts. Further, defendant shall provide documentation or bill summary that proves Capital One bill has been paid off and that card closed. And also, Mr. Humphrey is to pay $225 in attorney fees to Mr. Petrangelo. Has all that been accomplished?
No. Your Honor, first of all, I thought until about an hour ago we had an agreement to resolve everything, but that's not quite the case. At least every month, payments are late for my client's share of the pension payment. It comes on the 24th of the month. He's to pay it to her by the end of the month. He's to pay it through my office, and you've ordered that 3 times because he hasn't been doing it.
It's not being done?
Still, he's never once come to my office with one dime.
Right, Mr. Humphrey, do you understand the court's going to hold you in contempt for violating the orders of this court? Upon filing your pension, you could be ordered to serve up to 45 days in jail. Do you understand that?
Yes, sir.
Because possibly if jail, you have the right to an attorney. If you can't afford an attorney, the court will appoint an attorney to represent public expense. Do you understand all that?
Yes, sir.
Can you hire an attorney?
Excuse me?
Can you hire an attorney or do you need a court-appointed lawyer? Mr. Humphrey, you're inching your way close to jail. The court has no patience tolerance for the games you're playing. Can you afford an attorney? Do you want a court-appointed lawyer?
I'd probably want a court-appointed one, actually.
All right, I need to ask you questions. You're ordered to personally appear in this court 11:15 on Monday. Bring a toothbrush, Mr. Humphrey, because there's a really good chance you're going to go to jail, but we'll have an attorney represent you there. Are you available 11:15 on Monday, Mr. Petrangelo? I'm sorry, that's Memorial Day.
Let's see, Monday at
I'm sorry, I'm getting ahead of myself. We're closed on Monday. What about
yes.
What about Friday? Tomorrow?
I'm available tomorrow.
All right. Okay, Mr. Humphrey, are you currently employed?
I am currently employed.
With whom?
Great Day Improvements.
I'm sorry?
Great Day Improvements.
Great Day Improvements?
Yes.
You paid every week or every 2 weeks?
Supposed to be every 2 weeks. It's a commission based, so I don't always get paid. So
Okay, what's your approximate income? Do you get paid every month, every 2 weeks, every week?
it's supposed to be every 2 weeks. It's just a commission based. I'm starting out. I'm a retired teacher. I was in between jobs. I was unemployed when we first started the divorce proceedings, and then I started this job through the winter.
Take home every 2 weeks.
Oh, it's hard to say. Averaged out probably about 1,500 or 2,000.
Okay, your request for court-appointed attorney is denied. You can afford an attorney. The court does not believe you're indigent, Mr. Humphrey, so you need to hire your own attorney, or otherwise you can represent yourself. You need a week to hire an attorney?
Yes, sir.
All right.
Sir,
Okay,
excuse me, sir.
Okay, we're gonna set a date for contempt proceedings, Mr. Humphrey. I'm not gonna play games with this case. We're wasting too much of this court's time. So let's set a date. You have an attorney on board, a week from today. That'd be May 30th.
Okay.
Right, Mr. Petrangelo, available F-15 on May 30th?
I'm available in the morning. Is there any way you can squeeze us in then?
Okay, let me see, you got the docket, Keegan, the calendar.
Is that on Thursday?
Miss Cindy, can you tell us whether our schedule on Thursday, May 30th, please? 10 o'clock on Friday, May 31st. Available, Mr. Petrangelo?
That would work, yes.
All right, Mr. Humphrey, you ordered to personally appear in this court at 10 o'clock on Friday, May 31st for contempt proceedings. Bring a lawyer with you.
Okay.
Questions?
Yeah. I do a little bit. I will moving forward, definitely make the payments to his office. It's been difficult.
Mr. Humphrey, I don't want to hear this. There's a court order entered. It's just a question of whether or not you have complied with the court order, you're violating it. So you need to talk to an attorney because you're inching yourself close to jail. I'm very serious about this matter. That's why I'm not going to hear anything this afternoon. Talk to an attorney and you'd be here with or without attorney May 31st, 10 o'clock, personally, 4th floor of the courthouse, Braunlich courtroom.
Okay.
I'd suggest that attorney reach out to Mr. Petrangelo. Maybe he can resolve things in the meantime. But this is going on way too long, and the court has no patience with the games you are playing, Mr. Humphrey. Anything further this afternoon, Mr. Petrangelo?
No, Your Honor.
Okay, and we'll take things up by then, and I anticipate Mr. Humphrey will come into full compliance if he wants to avoid jail, full compliance within the next 7 days. Right, they can zoom out.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, now I start. There we go.
Can you hear us now? You're muted now. If you'd unmute, we can hear you. There, we hear you.
The court will call the case of Melissa Humphrey versus Michael Humphrey. This matter is before the court for possible contempt proceedings. And Mr. Humphrey was previously ordered to personally appear today on this post-judgment matter, but the court was informed just this morning by Mr. Petrangelo that the outstanding issues have been resolved and the presence of personal presence of Mr. Humphrey is not required. But nevertheless, Mr. Humphrey has appeared via Zoom this morning, as well as attorney James Petrangelo representing the plaintiff, Melissa Humphrey. And I don't know, is Melissa present?
She is not. She is out of town and has authorized me to speak on her behalf. I don't believe she was ordered to appear.
That's correct.
In this matter, Mr. Humphrey, by a message to me, made it clear to me he thought the hearing was at 2, and of course that's on him. But I did look back the hearing before the court order was for 2. I think he looked at the wrong order. He's been cooperative with me. We've reached an agreement. With this court's permission, I'll just announce the substance of it since he's on the record now, and we have an order he has signed. I will send over for the court signature.
Right. Is that all correct, Mr. Humphrey?
Yes, that's correct.
Right, Mr. Petrangelo, if you want to state that in the record, please.
Yes. First of all, there was an issue of a qualified domestic relations order. The issue was the judgment provided that Mr. Humphrey could change that to a 50% survivor benefit. The plan told us he could not do that. He has agreed to leave it as currently set with a 75% survivor benefit. My client has agreed to that. We've submitted an amended order, which has now been signed by the court, and he is agreeing to leave it as is. Under the terms of the judgment, my client was awarded a 2017 Lincoln MKZ automobile. She had to remove Mr. Humphrey's name from the indebtedness. Parties agree that she's traded that in now on another vehicle. His name has been removed from the debt. In place of remaining obligations related to that, the parties have agreed that Mr. Humphrey will pay Melissa Humphrey the sum of $2,100 to resolve this and other issues between the parties. That'll be paid by paying directly to her the sum of $262.50 biweekly, effective May 24th, 2024, until it's been paid in full. In addition, there was a Capital One credit card. The agreement is my client is no longer required to pay any amounts to the defendant on that. He instead will pay off the balance of the card, close it pursuant to a settlement plan he negotiated with Capital One that requires that he make 3 monthly payments of $692.48. The first payment's due June 25, 2024, and a like payment on July 25th and August 25th of this year. He's going to provide verification of the payments and the payoff. There were issues of outstanding income taxes. They've resolved all of the state income taxes issues. They've resolved the federal taxes for the years 2020 and 2022. For the year 2021, the defendant has entered into a direct debit payment plan with the IRS. He's provided verification of that. Under that, he's required to pay the sum of $236 per month on the 25th day of each month, starting July 25, 2024, until it's paid in full. My client will pay nothing on this indebtedness. This will resolve this issue unless there are additional charges due to him making late payments. He'll provide
So all this
verification
has
that he
been
pays
reduced to writing, and Mr. Humphrey has approved and reviewed that proposed order. Is that correct?
Yes, yeah, I have in front of me his signature on the order as I've recited it.
All right. Thank you, Mr. Benjo. Is that all correct, Mr. Humphrey?
Yeah, that's correct.
Do you have any questions for Mr. Petrangelo or any questions for the court?
No, I don't believe so. I guess the only thing that's uncertain is how I would make that the student loan payments. How you guys would like me to do that.
You want to pay those to the planner? You want to and provide verification?
Yeah, if I can do that, if I can pay directly to the plan, I'll do that.
And if there's a problem, you pay it to her. Just provide proof it's being paid by the end of each of those years.
Sure. Okay.
Okay.
Very well. The court's pleased to hear that these remaining issues have finally been concluded and addressed. And so we don't need any future review dates. Is that correct?
We do not, Your Honor. Obviously, Mr. Humphrey knows that if he doesn't follow the order, we would file a show cause on this. But we are in a good position right now, so I think we have a good chance of success.
Wonderful. All right, Mr. Humphrey, if some issues arise, communicate with Mr. Petrangelo rather than just ignoring things. Communicate with him. You'll find that he'll try to work with you, and obviously we want to try to avoid having to come back to court to enforce these agreements.
Okay.
So if there's no other questions, Mr. Humphrey, the court applauds you for finally reaching an agreement to wrap up these remaining issues so you can move on with your life, as well as Melissa. Thank you, Mr. Petrangelo, for your assistance, and the court will look forward and we'll enter that order upon presentment. You'll be mailed a copy of that after it's been entered by the court, Mr. Humphrey.
Okay.
All right.
Thank you.
All right. Thank you. Well, that will conclude this hearing. Everyone can zoom out and have the rest of the day and weekend.
All right. Thank you.
Are you Bradley Estes?
Yes, sir.
Good afternoon. Is Leanne Huffman present on audio? Is Leanne Huffman present on audio?
Yes, sir.
All right. Good afternoon. For the record, this matter is before the court on the motion for order to show cause filed by the petitioner Leanne Huffman, alleging that Mr. Estes has violated a personal protection order, and that Mr. Estes has made efforts to contact Ms. Huffman while incarcerated, requesting visits and phone calls. Do you understand the allegations, Mr. Estes?
Yes, sir.
Okay. For the record, Mr. Estes is appearing this morning this afternoon from the Monroe County Jail. Mr. Estes, what's your out date?
I got a sentencing date, June 6th. I'm not even sure. I've been in here since March.
Okay. What kind of sentence? What kind of conviction is it? A misdemeanor or felony?
They said it's a felony. I ain't been sentenced or nothing yet. I'm talking to a probation officer.
Okay, Mr. Estes, do you have no idea whether you're convicted of a misdemeanor or felony?
I think it's a felony because it's the Attorney General, right?
Oh, okay. You're being charged with felony non-support. Is that correct?
Yes, sir.
All right, that's a felony. It's a felony conviction. Do you have any idea what's been recommended, prison sentence or?
They said 4 years. They're trying to move all my stuff in Wayne County so I could get on probation there and start paying. I have a job, as of right now.
So your sentence is June 6th. Is that correct here, Monroe?
Yes, sir.
All right. But obviously you have no children with Miss Huffman, is that correct? Oh, you do. You have children common with Miss Huffman. I'm sorry, you do. Okay. You do. In that event, Mr. Estes, The personal protection order entered by this court on February 15th prohibits you from contacting Ms. Huffman unless it relates to the children.
Yes, sir. I sent a request. I didn't, it said on there if I could ask about my kids. I didn't call. I didn't get the protection order till I got in here. It was March 6th. I wasn't meaning no harm. I just missed my kids. I wrote the friend of court. I won't
You were
call.
served on, it appears in the court file, you were served with this personal protection order March 15th. And
Yeah,
further
yes,
appears
sir.
that you had made efforts to contact her.
Yeah, it was one
on April 14th, after you received this PPO. Mr. Estes, you cannot have any contact with her. You understand that?
Yes, sir. Yes, sir. I'm sorry.
How old are the children?
4 and 1.
Okay. Well, obviously you can't really write letters to the children, but
I just thought maybe she's seen the request if she would let me talk to him or not. That's my fault. I'm sorry, sir. I won't do it again.
all right. Ms. Huffman, when you receive a phone call from the jail, you have to accept a collect phone call. Is that correct?
I did receive a phone call, but I denied the phone call.
Okay. Well, that's just, you have some responsibility here too. Obviously, if Mr. Estes calls you, just refuse and hang it up.
I understand that. There's been PPOs for 2 years, and he's been continuously violating them. Not this one time, but for 2 years. I could never get him served because I did not know.
Hold on. This PPO was entered February 15th of 2024. So I don't know about a 2-year PPO. If there's one before that, that's another issue. Of course, when you're looking at this February 15, 2024, Mr. Estes has acknowledged that he tried to contact you, but again, you can avoid that contact by simply don't accept the collect phone call.
I did. And then there was an email and another email.
Okay. How can he send you an email? Is there some way
I'm
can
not
you block
sure.
that?
It came from the jail. I'm not sure. I don't know.
Why don't you?
That's what
the
I
court suggests.
screenshot.
The court would suggest write a letter to the Monroe County Sheriff and advise them that Mr. Estes is communicating with you contrary to a personal protection order, and you don't want him to be permitted to issue any emails. They'll perhaps take away those privileges from him.
Okay, Your Honor.
And maybe there's some way that you can block it on your computer. I mean, if you see an email, just block it. Don't even open it. Just ignore it.
We blocked it.
Is there an office? So do you acknowledge having emailed Ms. Huffman, Mr. Estes?
We had them blocked after that. I asked them to block them. So they're blocked as of now, everything. And
you asked who to block them?
Mr. Ramestad, Sergeant Ramestad, he's actually in here with me.
Okay. So do they take away computer privileges? How do they block it?
Your Honor.
Oh, yes.
Sergeant
Yes,
Ramestad.
sir.
Yes.
Good afternoon. Thank you.
Yes. So Mr. Estes approached the cage when he got served with the paper, approached the officers in the door when he got served his violation of the PPO. He asked if I would block any access for phone calls and emailing, which I did in the ICS solution. So there should be no further contact being able to be made on his behalf.
Wonderful. Thank you, officer. Thank you. Did you understand all that, Ms. Huffman?
Yes, thank you.
So the Monroe County Jail has taken steps to prevent Mr. Estes from emailing you or calling you. So again, if in fact it happens to slip through there, or if he goes to a prison facility, Mr. Estes, don't reach out. I mean, there's no communication. This PPO is valid for 1 year, won't expire until February of 2025.
Yes, sir.
So if you want to contact the children, you write to the front of the court, write to your sister, write to your mother, maybe someone else can give you an update, but do not contact Ms. Huffman.
Yes, sir. Yes, sir.
Attorney. All right. So Ms. Huffman, does that address your concerns? I don't see any purpose in having giving Mr. Estes an attorney and going through contempt hearings and all that. The court will simply note that he's been instructed and warned not to have any contact. There's a system in place right now. The Monroe County Jail will enforce that and make sure he does not have any capability to phone you or email you. So is that satisfactory to you, Ms. Huffman?
It does, but he will be released probably within 2 weeks, and I'm just concerned about the harassment in 2 weeks as well when he is released.
Well, you can file another petition, but it sounds like he's going to prison.
Okay.
I mean, if he's got his child support, that's a felony offense. He's going to be sentenced on June 6th. Obviously, you can attend that sentencing, but it sounds like he's unless he can come up with a significant sum of money, the court's most likely to impose a prison sentence. But this is a family court, not the criminal court, so I don't know that, but you should be in touch with the criminal court. Well, what judge is this case, your criminal case assigned to, Mr. Estes?
White. White, sir. Judge White.
All right, so Ms. Huffman, Judge White will be imposing a sentence on June 6th. You can call us off, find out what time sentencing is, or Mr. Estes, what time is your sentencing on June 6th?
I think at 1:15, I'm pretty sure, yes, sir.
So make note of that, Ms. Huffman. You can always reach out. You can attend sentencing. You can speak to the court at that time.
Okay, thank you, Your Honor.
And it sounds like he's going to be a candidate for prison. So in any event, but at least while he's in the Monroe County Jail, he'll not have access to any means to communicate with you by email or by phone. So we will simply warn Mr. Estes at this time. He acknowledges he's aware of the PPO, no contact, no communication. And with that, we'll conclude this hearing. All right. Good luck, Mr. Estes. Thank you, Ms. Huffman. The motion of Kerry Vaughn seeking to terminate a personal protection order, which was entered by this court on March 11th, 2024, 2 months ago. Kerry Vaughn, you are present, is that correct?
Yes.
Okay, the court will note this matter is scheduled for hearing via Zoom, being conducted via Zoom. Is Logan Vaughn present?
No, he is not.
Okay, he's not.
Was he supposed to be present?
It's up to him.
Oh, okay.
Ms. Vaughn, you indicated in your petition that you do not feel threatened. Well, obviously you did 2 months ago, and he's now sober. If he's not alcoholic, he's sober for a period of time. Ms. Vaughn, and you want to have contact, you want to live with them. This PPO does not prohibit that. This PPO simply prohibits Mr. Vaughn from assaulting you or threatening you. That's it. You can sleep with them. You can have meals with them. You go to dinner with them tonight. Read the PPO. It does not prohibit you from having contact. But this court will not dismiss this PPO. It's valid for 1 year. This court is not a game where we enter PPO 1 month and we drop it the next month. So this will expire March of 2025. Again, I just want to make sure you're protected. This court takes these things seriously, Ms. Vaughn. We don't just grant them 1 day and drop them the next day. So it will continue. The court's going to deny your request to terminate. But look at your PPO. It does not prohibit you from living together.
We were stopped, and he was detained, and the police said that we had to, if we wanted to be together, that we had to terminate the PPO.
It's not true. Look at your PPO. Do you have a copy of it?
I do, but I don't have it with me right now.
Well, you should probably carry it with you. I mean, there's no reason for him to be detained. I suppose initially they want to inquire to make sure there's no violation of the PPO, but you look at the PPO, it simply prohibits prohibits him from assaulting you, threatening to kill or injure you, or interfering with your employment. That's it.
Okay.
So, I mean, an officer obviously just didn't read it. But you should, if in fact you're going to be hanging out with Mr. Vaughn, keep it in your purse, carry it with you, so that you can present it to an officer.
Okay.
And we wish him well in his sobriety. But again, I don't want you coming back in 2 months and want another PPO, Ms. Vaughn. So the court's going to deny your request to terminate this. All right.
Okay. When did you say it expires? March 1st?
Well, it's 1 year from the date it was entered. It was entered on March 11th, so it'll expire March 11th, 2025.
Okay.
10 months.
Okay.
All right. Good luck, ma'am. You can zoom out.
Court is now in session. Page 5, Taylor Vaughn versus Logan Vaughn Jr.
For the record, this matter is before the court on the petitioner Taylor Vaughn's motion to terminate a personal protection order entered by this court on March 11th, 2024. This hearing is being conducted via Zoom. You are Taylor Vaughn, is that correct, ma'am?
Yes.
Is Logan Vaughn present on audio?
No, he's not.
Here's Mr. Vaughn is not present. You've alleged to Ms. Vaughn that you do not feel threatened anymore, and he supposedly, Logan Vaughn has stopped drinking. Well, perhaps temporarily. But the court treats these PPOs very seriously. The court it's not a game where you get in one day and drop the next. All this does is prohibit, you can have contact with Mr. Logan Vaughn, but this prohibits him from threatening you or assaulting you. That's it.
Okay.
You can have dinner with him tonight. This is not prohibited contact. So read your PPO.
Okay.
People do not read these. You got to read them.
Okay.
So this will expire automatically on March 11th, 2025, 10 months from now. This court
Okay.
will deny your request to terminate this. I want to make sure you're protected. And again, the court treats these seriously. He may be not drinking today, but he may be drinking next month.
Okay.
Any questions?
I don't have any questions.
Okay, court will enter order denying motion to terminate, and the copies will be mailed to you.
Okay.
Right, good luck, ma'am.
Thank you.
Welcome.
I'm not even.
He's not drinking very well. He was intoxicated. He assaulted both of you. Okay, so he didn't drink.
Boyd versus Tyrone Stokes.
For the record, this matter is before the court on the petitioner Raven Boyk's motion to terminate personal protection order, which was entered on April 19th, 2024, only a month ago. This hearing is being conducted via Zoom. Are you Raven Boyk?
Yes, sorry.
Okay. Is Tyrone Stokes present? It appears that he
No,
is
he's not. I
here.
tried to call him. I guess his phone's not going through. No.
Right. This matter was set at 3:15. It's now 3:30. It's not necessary he be here. You've alleged as PPO that you filed this PPO out of pettiness. Well, this court does not play games, ma'am. So this court will not terminate a PPO.
Okay.
And I will let, so this will expire. It was entered just a month ago. This is not a game. The court's offended. You come back within a month. Obviously, so you allege that he assaulted you, hit you. So this PPO prevents him from entering onto your property, from assaulting you, threatening you, or stalking you. In other words, you can have contact with him. You know, if you want to meet him at for dinner, you can do that. But just don't. If he goes to your home or your property, I mean, he's risking being arrested. So if you want to have dinner with him, you want to sleep with him, do it somewhere other than your home, because he otherwise he place himself in jeopardy. If there's an argument and they come over to your house and he's there, they're going to arrest him.
Right. Okay.
So if you're going to have a contact with him, do it somewhere other than your home. But the court will deny your request at this time to terminate this PPO. Will continue. Again, look at your PPO. It's very specific what it prohibits. It prohibits them from coming to your home, threatening you, assaulting you. So you have children together, correct?
Yes.
So obviously there's an order in place that tells you where to conduct the exchanges for parenting time purposes. Is that correct?
No, we don't have any type of agreements or anything.
Well, you can always talk in front of the court caseworker. You should get an order in place where his parenting time is these dates of the week, and that you meet at the, say, the sheriff's department or city police department. So it's a neutral location. So he's not coming to your home.
Okay.
You want to minimize conflict. All right. Do you have any questions, Ms. Boyk?
No, I don't.
All right. The court will deny your motion to terminate. It will terminate automatically on April 19th, 2025. That will conclude, sir. You can zoom out. Have a good rest of the day.
Okay, you too. Thank you.
Yep.
Court is now in session. Cheryl Kerber versus James Kerber.
For the record, this matter is before the court for continued pretrial conference. The same is being conducted via Zoom. President Attorney John Danielski representing the plaintiff, Cheryl Kerber. Ms. Kerber appears to be present, and Michael Jones is present representing the defendant, James Kerber. Mr. Kerber is also present. Good afternoon, everyone.
Good afternoon.
The court's informed the parties are still mediating with Mr. Pepper this afternoon. Is that correct?
Yes, Your Honor. We have a long-term marriage, approximately 33 years.
What's aware of that?
So
I want to keep tabs on this case. Do you anticipate scheduling another mediation, Mr. Danielski?
I think so. We're making progress. It's slow, though, Your Honor.
Okay.
So there's a lot of documents, a lot of stuff to go through, a lot of assets.
Has discovery been completed?
We have, go ahead, John.
We both exchanged significant amount of discovery. I do have some, based on what I received, some additional questions. And frankly, I was hoping if Mr. Jones and Mr. Corber have time to continue after meeting with your honor today, because I do have some additional questions. But we've exchanged a lot of discovery. I mean, we're almost there. There's probably a few more things to exchange.
Okay.
And we have talked about a certain, I think the second week in June or third week in June, we're taking some steps if we have to, Judge.
Just the court wanted to keep tabs on this matter. There's Mr. Pepper. Good afternoon, Mr. Pepper.
You're muted, Jeff.
You're muted, Mr. Pepper. If in fact another mediation is scheduled, do you have a prospective date so the court can just keep tabs on this for another pretrial after that mediation?
Well, I haven't scheduled a date with them yet, but I can give them these dates right now for the next month. I can do that. It's one of 2 in May and one of 3 in June. So we ought to be able to get one of those. And the last one would be on the 12th of June. So between now and then.
Okay. Thank you, Mr. Pepper. I appreciate you appearing.
Okay. Thank you, Judge.
Counsel, can you look at your calendars and maybe suggest a date that you're available to meet again with Mr. Pepper? And the court would just send out notice of a continued pretrial conference after that continued mediation?
I can come back in May, Jeff, if you got a date before the end of the month.
I do. It's the 29th, 29th in the morning.
I can do it.
Mr. Jones, how does your schedule look?
I'm available.
Okay.
I'm available.
What time would you propose, Mr. Pepper? 8:30, 9 o'clock?
That'll be 8:30, yes.
8:30, May 29th, which
Yes.
Is actually a week from today. It's next Wednesday, correct?
Yes.
All right. Mr. and Mrs. Kerber, does that date and time work with your schedules?
I guess so.
Yeah, I don't know of any conflicts. I'm
Okay.
clear.
Well, it does make sense to continue the discussions while things are warm. And I will assure you, Mr. and Mrs. Kerber, you're represented by 2 very capable family law practitioners. And with the assistance of Mr. Pepper, the best resolution of case of this nature is one which you both participate and ultimately reach agreement. So please keep an open mind as you continue the discussions. But the court will mail out notice to counsel for continued pretrial conference, May 29th, anytime. If you're starting, that's wonderful, starting the mediation at 8:30. So we'll just look forward to hearing from you whenever you conclude with Mr. Pepper.
All right.
All right. Thank you, Mr. Pepper, for being
Okay.
available.
Thank you, Judge. Nice to see you.
Interrupt. Thank you, sir. Okay. That will conclude this matter. Good luck. Have a good rest of the afternoon.